Sorry, Samantha.
Hello. Okay, I am obviously not Kate Eastman. She's stuck in court and is on her way, but set to get started. So she's hoping to. She's in a hearing that's run over time, so she's hoping to be here very soon. And as soon as she gets here, I will hand over to her, but I'll get things going. Thank you all for coming to this second session. And in contrast to the first session, this session is all about getting practitioners that are very experienced in the area of refugee litigation to talk about what their involvement in strategic refugee litigation looks like, what the challenges of that are, and what scope they see for leveraging academic expertise in the process of strategic litigation. What are the opportunities in leveraging academic expertise, and also what are the challenges in making that work successfully. So on our panel here today we have Teresa Four from the New South Wales Bar, been at the bar since 2006 and has a specialised practice in public administrative law and migration law. She does a lot of work on all aspects of judicial review and has appeared unled in various jurisdictions, including the High Court, the Full Federal Court, the Federal Court and the Federal Circuit Court, where she's done a lot of recent work, as well as Supreme Courts and other state courts and tribunals. She's appeared in a number of test cases that have created new law and landmark decisions that are regularly referenced in courts today, and has also had international experience in the Supreme Court of Nauru. Next to Teresa, we have Kate Gillingham, also next to Kate, for hosting us at this beautiful premises, Baker and McKenzie, today. Kate's the pro bono partner at Baker and McKenzie, and one of the key focuses of her pro bono practice is asylum seekers and refugees. And over the 4 years that she's been in this role, Baker and McKenzie has worked with a number of partners, including community legal centres, to provide pro bono legal services to asylum seekers. She's got a broad range of strategic litigation expertise and has acted for asylum seekers, again in the areas of judicial review of negative protection visa decisions and in the Nauru context, as well as in cases relating to citizenship. Next to Kate, we have Katie Robertson. Thank you very much to Katie for agreeing to be on this panel. Jeffrey Watson, who was originally scheduled, was unavailable, and very grateful to Katie for coming up for this. Katie's a senior associate in Maurice Blackburn's social justice team in their Melbourne office, and she's got very extensive strategic litigation experience in the refugee space, and I know has worked with a number of people in the room. Her key cases include the Baby Feroz matter, which prevented the transfer of over 100 Australian-born asylum seekers and their families to Nauru and their ultimate release from immigration detention into the community in Australia. She's also acted for a refugee injured in the 2014 Manus Island riots, and more recently a 6-year-old asylum seeker who suffered injuries while detained on Christmas Island, and also has an interest in the citizenship rights of stateless asylum seekers. And finally, we have David Mann from Refugee Legal on the end of the panel. He needs no introduction. He's a human rights lawyer, migration agent, executive director of Refugee Legal, has been working in the refugee and asylum seeker space for over 20 years, has an impressive 9 out of 9 track record in successfully arguing high court challenges in the space of strategic refugee litigation. I won't talk anymore because actually what I wanted to kick off this panel discussion with is by asking each of you all practice regularly in the area of strategic refugee litigation, but come to this process from different perspectives and enter this process at different points. So I was hoping that each of you might be able to give the audience a little bit of an overview of what your day-to-day work on strategic refugee litigation looks like when you enter the process, who touches a case before you and after you, and a little bit about your work in this area.
Thanks so much for that, Sangeeta. So I come into the case after the client, the refugee asylum seeker, goes to a solicitor first. The solicitor looks at the case, decides yes, if they needed to take it to litigation and they needed advice on prospects for applying to either the Federal Circuit Court or the Federal Court. They usually come and brief me at that point for an advice on prospects. Sometimes the matter has actually already been started and commenced in the courts, so on that basis I may run the argument that's already been put in the proceedings, in the application or the notice of appeal, or I may amend. And sometimes it can be done within the court time frame because courts often allow for an amendment to the application or notice of appeal, or it must be done by leave of the court to run it on some other grounds that I think has reasonable prospects. So then, by the stage it gets to me also, usually evidence may already be put on or it may not have. There isn't usually that much evidence that needs to go on for refugee cases because the decision maker, usually the tribunal, has already got what becomes a court book in the actual court. I don't know how many of you already know all this information, so this may already be, I don't know, sucking eggs for most of you. So the court book already has the material upon which the decision maker has made its decision, the tribunal member. So that is already going to be tendered in court. The only other extra evidence usually that we would come across is a transcript of the tribunal hearing. So that's where oral evidence comes in, the oral evidence of the applicants, the asylum seekers. And what I would normally do is the most intense work would be formulating the actual grounds for the argument and then writing the submissions and considering the other side's submissions. So what can we say against the minister's submissions? So all of that, I don't really need to deal too much with the client in gathering any kind of evidence or anything like that, because as most of you would know, judicial review is not a merits review. So we're not looking at the question of are you a refugee? It's whether there has been some kind of error of law in the decision maker. So a lot of the time I don't need to have a conference with the client, but often the solicitors will ask me to do so for various reasons. They want to know the legal process, they want to meet who's going to represent them in court, and more recently some solicitors have asked me, and I'll probably come to this in the next question, but especially when they are confronted with judges that will most likely reject their case, they often want the barrister to tell them that. So they'll probably come to another question, but then I appear in court. So that's where the crux comes. It all comes down to the arguments that I'm making and how persuasive I am for the court. And then once the judgment is handed down, whether or not we need to appeal, I'll look at the prospects of whether we can appeal the decision.
Thanks, Teresa. I'm just sitting at the panel and realising that there's 3 Kates up here, which throws me back to school, where we had Kate 1, Kate 2 and Kate 3, so I'll be Kate 2. So yes, I'm the pro bono counsel at Baker McKenzie, and when I started in this role about 3.5 years ago, one of the focus areas I wanted to build was our practice with asylum seekers and refugees, and so that has been slowly building. And we regularly do litigate for asylum seekers. Most recently, I have had the opportunity to be involved with a couple of the Nauru matters and run those. And I think one thing I've learned through all of the litigation that we have done for asylum seekers is what the panel speakers before have spoken about, and that is the importance of collaborating and working with other organisations in this space. So as a big law firm, we obviously don't have immediate access to those asylum seekers who we represent. So we work with community legal centres such as RACS or Refugee Legal, and with Nauru we've worked with Human Rights Law Centre, who have built on the work of George Newhouse with his National Justice Project and the Asylum Seeker Resource Centre, so that we get those cases referred to us. With the Nauru work, once that came in and we had this fabulous guidance from the Human Rights Law Centre, it meant that we were able to run those matters with actually very little capacity. So actually in the second one it was just me, and it was fine because we knew what we were doing. We had this fabulous background memo. When we were litigating, we worked with, as we always do, interpreters, counsel, expert witnesses, so psychiatrists in a Nauru case, and also other witnesses, so they were former caseworkers or doctors on Nauru, and organise their affidavits. Once the cases were over, we then almost sort of go through another transition period where we work with Human Rights Law Centre or the Asylum Seekers Resource Centre, because it's then a matter of managing the client's expectations. You can imagine that no matter how often you explain to them when they're on Nauru what the scope of your work will be, and that is to get them for medical attention. Once they're here, they're still on their own and they need support, so that's when we try to transfer that back to the other organisations in this field. As I said, we do a lot of judicial review work, and Teresa's talked a bit about what's involved there. But we have also done some cases for bogus documents. So these cases are where the government seizes identity documents on the basis that they are bogus. That's important for asylum seekers when they're applying for visas. We don't litigate in that area, but we have litigated for refugees who have applied for citizenship and had their documents seized that way. And that's where we have had to involve academics in giving evidence, and we can talk about that later. But again, it's that whole process of working with other organisations, from getting clients in and then once the matter's finished, passing that on, and Amnesty International actually helped with that.
Thanks. So my role and my team's role is a little bit different in this space, in that we run essentially public interest litigation. So when we're considering matters that we might take on, we're looking at running a case perhaps on behalf of an individual that will have an impact beyond that individual. And we always are looking at it in this context in terms of ways in which we can develop the law in a progressive manner. So we don't do migration work like David and his team and RACS do very well. We tend to look more at conditions of detention, creative ways to prevent removal of people from Australia to Nauru or PNG, ways in which we can bring them back. So we've recently been involved in a number of the Nauru injunctions, Previously, we've worked on creative arguments around which we can argue that a certain person does not meet the definition of someone who should be removed from Australia. And then more recently, we've done sort of bigger, larger scale litigation, class actions, where we're trying to capture and fight on behalf of a large group of people. And I suppose we use litigation as one tool within a broader strategic strategy of trying to achieve progressive change in this space. So litigation in the context of broader advocacy, campaigns, political strategy and lobbying, and media where appropriate, particularly on the political front. As Angus can attest to, I've had a couple of cases where there's talk of the legislation being amended while our case is on foot, and in one particular case, legislation was amended while our case was on foot, which we'll talk to later in terms of the challenges of working in this space, particularly where you have bipartisan support for pretty tough policies. And so we're really involved, and I'm involved from go to woe. I do a lot of work with clients, both in terms of sourcing cases, working directly with clients in very difficult and stressful circumstances, right through to litigating, doing advocacy, and seeing that matter through. But also, as was mentioned this morning, we often have cases that we think would be good to run, and it's a matter of actually finding a client, which in some of the more obscure cases and some of the more questionable practices our government's engaged in over particularly the last 5 years with vote turnbacks or other stories you hear about the behaviour of border force officials when they're turning back votes. It's actually how do you find that client, and even then, accessing clients when you're on the record as acting for them becomes increasingly difficult when people are held offshore. So that's just a bit of a snapshot of the work we do.
Thank you. Our model with strategic litigation is very much to initiate, to set up and then lead the litigation, but probably the most distinctive aspect of our model is that we don't identify an injustice, a systemic injustice, and then look for a vehicle, that is a client, to bring the case. We actually have the clients, and so really a lot of the identification of systemic issues comes through the client work itself, the identification of systemic injustices, harm, etc. And we never have any difficulty finding a client who may be the representative plaintiff, because we have often hundreds, if not thousands, of potential clients. So that's very much the way in which we do it generally, and that's the general approach. And then just to give you 3 ideas in this sort of very quick snapshots. One is the M61, which most people will be aware of, the offshore processing case in 2010. That arose from clients that we were already assisting under the sort of offshore processing arrangements at that time on Christmas Island. And we were helping literally hundreds, if not thousands at that time, people who had arrived by boat and were being assessed according to the government in a process unconstrained by law. And the challenge arose really from the refusal of some of our clients, and they were some of the first people refused under that process of the sort of merits review stage. And what we really then needed to do, in fact, it was the first group that were actually flown from Christmas Island to Sydney, and it was as if the borders had been breached. It was a dramatic episode. And we went to Sydney, myself and a senior lawyer from Refugee Legal went to Sydney, and we met with, there were at least 100 men in a room in Villawood, and we spoke to them. And the idea was that we met with them, and we already had the sort of formed a view about a case that could be brought, an initial view. And just to give you a sense of the model, that we formed that view together with counsel. So we'd had some initial discussions with counsel, and as with almost all of our cases, they start with some key ideas and you develop them from there. And we at least had an argument, or what we thought were a few arguments, and then really it was a discussion with the group about who would be interested in being one of the plaintiffs. And a number of men in the room that day stepped forward and said, well, I'll put my hand up to be one of the possible plaintiffs. And then we went through an exercise of working out which of those men would be the best of the plaintiffs in terms of the argument. The Malaysia case actually happened a year later. That happened literally as I was cooking on an early Sunday evening, and Saturday evening actually it was, and just got a call relayed through another lawyer, a duty lawyer of all things from legal aid in the ACT, and had somehow got a call from Christmas Island and from one of the men, and they got in touch with us, and it went from there. And so again, it was very direct. It was with, we ended up speaking with quite a number of men who were literally about to be removed to Malaysia. And that's probably a good example again of how the model works, is that we'd already had some discussions with lead counsel that we work with often, and this goes back to the issue of relationships too. And we're able to call them on a Saturday evening. We're able to call Ellen's. Ellen's is one of our pro bono law partners, and through some wonderful legalese, they were able to get approval overnight. I won't go into how that came to proceed with the case, but it was really one of those arguments in the absence of a no, it must be a yes. And so really what happened was that, literally overnight, counsel swung into action. We already had an idea of some arguments. They pulled together some juniors at the bar who were interested. Alan swung into gear with an army of lawyers, and we were in the High Court seeking an injunction on Sunday evening, so the next, with, I think 3 or 4 arguments, one of which Justice Hayne seemed to be interested in. The others he sort of gently encouraged we might drop. And the essence of the argument he was interested in ended up being the essence to the ruling by 6 out of 7 High Court judges, really. But again, the key to it really is we act directly for clients involved. We draw upon a team of counsel, and we always work for a large law firm, and there are a number of them. And it's a partnership, it's a true partnership. And I actually think it's very, in a way, it's a very strange thing in the law to have something that's so sort of, in a way, non-hierarchical. But there are very clear roles that each of us play. And we do lead it. And when I say lead it, it doesn't mean sit like that in a team, but we have a very particular role. And just one other aspect of it, of that role, I think, which is critical to strategic litigation, is the way in which it unfolds publicly. And so we work very closely with the team and with in the partnership on how we're going to present this publicly. And there are different, and it hasn't really come up today much about purposes with strategic litigation. It's probably not the key issue today, but there are different styles of strategic litigation, and I think in the partnership it's very important that everyone be comfortable with the style and the purpose. And I won't go into our style and purpose, but there is a way of doing things which some of you will be familiar with. The public interest law obviously has a very public element to it. It obviously is really implicitly using law as an instrument of social change in many ways. The way in which that plays out is a critical part of the discipline. The fundamental, I'll just finish with one thing, and that is that it leads from the idea that we don't go looking for someone as a vehicle, which is quite acceptable, by the way. I'm not suggesting there's anything problematic about doing that, but it's just not our style. But it's very, very much focused on individual and collective rights of clients. And that matters because, without going into detail now, I just want to, one quick note on that sometimes in strategic litigation you can be even part heard in the High Court, and the court is notorious for 1 or 2 or 3 judges, all of a sudden some different argument coming up that no one has thought about on either side. And then they'll say, we'd like both sides at lunchtime to think very carefully about this argument, and we'd like to hear from you. And some of those arguments can then involve that dynamic, which most of you will be familiar with if you've been in legal practice, where counsels start to go, look, I don't know if we should push this argument. I know we thought it was good, but I don't know, maybe we should just let go on that one. And that can very much bring in, again, the issue about why we're doing this litigation. What are the consequences for the client and others? And so our role in that is really to make sure that the client's interests are absolutely constantly square in line.
Thank you all so much for that. I kind of want to move on to have a little bit of an organic discussion about what I know a number of you have alluded to, things that are challenging in the running of refugee litigation, or the strategic running of refugee litigation from the various perspectives that you come from. And I wanted to tap all of your brains on what you see as challenging in running litigation in this area strategically in a way that you see as impact driven, and also what you see as the opportunities that exist for strategically run refugee litigation. There's various mics on the table, so I won't feel compelled to pass this one around. But does anyone want to kick us off?
I'm happy to kick off, but actually, this is what no, it doesn't.
Yeah, sure.
But in a way, it already has kicked off in the previous session. So I think some of the big challenges jurisprudentially have already been explored. So I don't want to go over them too much. But I mean, the first one, in a practical sense, is actually just resourcing, because at least our model, and I think it's not an uncommon model, this is that one of the ideas is we're dealing with people who almost always have never had anyone, let alone the law spring to their defence. Right? They're very, very vulnerable. And one of the key strategies is to actually ensure that someone's rights, even in this very vulnerable situation, that they're on equal footing before the law. And that leads to a very practical consideration, that is making sure that you can turn up in the court with as good a team or better in terms of both the force of argument and the resourcing behind it as the Commonwealth. And it's a practical but very, very important thing as part of certainly our model, and I'm sure it's the same with others. And so resourcing is one of the key challenges, I think. But it's not just it's not just the amount of people, but it's also those with expertise in different areas in the team, and that will vary. I mean, I would think one of the most important things is to ensure that your team has some really strong expertise with litigators. Sorry, just litigators, people that have really good litigation experience. It's probably one of the best groundings in refugee strategic litigation, is probably commercial litigation actually. But it's just the fundamental tools of litigation are critical. It's part of it. Look, some of the other challenges very quickly, and then I'll hand over. I mean, one of them is I just think, which has already been explored really, is the restrictive nature of the law in Australia, and it's been covered quite well already. But I think it's rights light in our constitution, as we know. It's very rights light. It's very sort of nascent in Australia. The idea of putting a human rights construction on legislation or common law anyway. So that's another real challenge. And I think I also think a real parochialism in Australia about how we look at refugee law. I mean, by its nature, refugee law is international. The underpinning idea of it being about cooperation sharing, about international cooperation, and yet so much of our system is so inward-looking and parochial in the way in which structurally and in the way that it plays out. I also think one final point I'd make is that there has been an incremental and systematic erosion or evisceration of foundational principles of protection under Australian law, and that is one of the great challenges, how to navigate that. The one that we've experienced, particularly with our cases, is what I describe in the Malaysia case as perhaps one of the most starkest examples, is that on what was a very important case, very important victory for refugees in many ways, and rights of refugees, is that within a year the statute is stripped bare of the protections, and so you'd sort of I would describe it as an exercise in taking the law out of the law. So that's one of the great challenges. Where do you go from there? So I'll hand over.
I think you've nailed a lot of the common issues, but just adding to some of your, I think, the sense of urgency in these matters. The urgency in these matters is a real challenge as litigators, but in terms of gathering the evidence you need, it always happens usually on a Sunday night or a Saturday night, guarantee. And I think there's a strategy that goes on there by the department. I think in that space, for me as a practitioner that has always worked closely with clients and is very passionate about making putting the client front and centre in every case I run, ensuring that client has agency and has control over their matter. As David mentioned, you're dealing with people that feel completely powerless and have fled a situation where they've had that experience for a long time and then experience pretty horrific circumstances when they arrive in Australia. So making sure people understand what the legal case is about, people understand what their options are at each and every stage. It baffles me continually. I'll be in meetings. Was in one recently where there was this big intellectual discussion over what the best course of action was, and I actually said at one point, what does the client want? Sort of crickets in the room. That really frustrates me, particularly within that we're acting for children often or victims of sexual assault. You've got to be alive to all those issues, which many of you are in that room, and balancing the fact that people are needing it's a high degree of need for confidentiality because people are seeking asylum, and the government really manipulates and relies on that. Secondly, on resourcing, it is a David and Goliath battle. Even when you have large backings of big firms, the government fights each and every stage of these cases with whatever they can. There's, this idea of a model litigant is a topic for another day, but it's a long haul fight, and within that context, constantly weighing up what is in the best interest of your client, given their current circumstances and health issues. And just, I think, finally, I agree that I'd say there's not a great appetite in the Australian judiciary, in the court system at the moment, for creative litigation in this space, or even an understanding of what vulnerable people or refugees are actually dealing with, and that is the difficulty as well that feeds into evidence. How do we get evidence in play that gives a judge that perhaps has never come across or interacted with an asylum seeker or a refugee some sort of insight into what their circumstances are?
Thanks, Katie. So I'd echo David and Katie's thoughts, but one point I would emphasise, and I think Teresa has touched on it, is one of the biggest challenges that I find is actually managing the client's expectations. So whether it's a judicial review matter or an ARU matter, they are initially really excited and think that they've won the day just because they have a lawyer. And so it's this constant reminding them that you think you've got reasonable prospects, but that's no guarantee. And if you lose, these things will happen. You'll be ordered to pay costs. If you can't pay the costs, they'll prejudice any future visa applications you make, all of the emphasis that you put on that. And then if you do lose, then you do have to deliver that news, and you do need to be prepared to tell them what happens next. Will they be put back in detention? What will happen in terms of deportation? How you can link them to a migration agent? And I think for me personally, that's probably the biggest challenge of the job.
Thanks very much, Kate. I'd like to also emphasise what you just mentioned, because yes, I did touch on that. So you probably noticed with my work, it's kind of like the day-to-day going to the federal court. I think I've been to the High Court once or maybe twice with the special league. So it's not strategic in the sense of, really big cases, but just the day-to-day, everyday asylum seeker, the thousands that are out there. One of the things that they don't factor in, which is part of every single litigation, whether it's commercial or refugee, the judge. You don't know who the judge will be until it's listed. So when you've already told them, yes, this case has got prospects, reasonable prospects of success, then you get your judge, and it's maybe only 1 month out from the hearing. I get called in, I get called to say, okay, we need a conference, you need to talk to the client about what's going to happen with this judge. Because it is a huge factor, and it might be even in a full court. If I see the names of the 3 listed in the full court, that's going to change the tone, right? They might be very, very conservative judges. My view on prospects can go 180 degrees. And that's something to manage with the client from the get-go. I had that actually yesterday. The client came in this particular Federal Circuit Court judge, and the statistics have already been done, more than 99%. So most of you will probably know what I'm talking about. Statistics have gone up to the full federal court, so it's more than 99%. I had to tell him from the get-go, it's better to know now than after the case when he loses. However, luckily today we got a win, an ex-temp win, and I am it's a miracle twice before this judge. So yes, definitely.
You are the 1%.
Well, yeah, there are some barristers who refuse to appear before him, I know, by policy. Yes. Yes, okay. So that's one aspect. The other thing I think David and the other speakers have touched upon is the team effort, and I would totally agree with that. I have had test cases where the solicitor has strategically thought of arguments. We have been before the full federal court. The full federal court has maybe thought of an argument this way or gleaned it this way, shed light on it this way. I go in the break at lunch talking to my solicitor saying, I don't know whether we should be pushing this argument, they're really not taking to it. He's like at the very beginning saying, okay, yeah, we can think about it towards the end of lunch. He's coming back and going, no, we really need to press this argument, we really need to press it. And I'm like, okay, as my instructing solicitor who's bringing this test case to me, I will follow your instructions, even though my gut feel was different. We won on that ground. So yeah, it is very a team effort, and it's really good to have the different aspects, the different people. I don't work so much with junior counsel because I'm not a senior counsel yet, or I don't know if I ever will be like Kate, but when I have had a reader like a junior and they've come into the case, they've done particular research on something else and they've shed light on a really good point, and I would say again, solicitors that bring another set of eyes to it. So it's not just the all and end all counsel's view. So yes, it is a team effort. I think they're the only main issues. I think the other aspects I might go on to the other questions.
Full confidence, but it's really one of the great challenges I think is to reconcile what an inherent tension in this work between individual rights and collective rights, and in strategic litigation, and it's always there. Sometimes it's more graphic than at other times, but it's to reconcile that, the individual and collective rights, and also the broader socio-political ambitions that may be at play. From our point of view at least, there is a sweet spot, but there is a real discipline to finding it, and it's really come up in some of the conversation already, but it does start with, and it's located in striking the right balance between the predicament of the people that you're representing and the broader aims, the broader policy and political change aims that may well be there, or the social aims of social change. So they can be reconciled, I think, the ethical and strategic imperatives, but I think one sort of note too on that is that courts in Australia are very much geared to the individual rights, protection of individual rights, and very much based on statutory, common law and constitutional constraints. So, I'll give you just one quick example of that one of our lead silks in one of our cases before the full bench made this terrible faux pas that all of a sudden he referred to the right to liberty. And the bench, everyone leaned forward and as if he'd sworn. And the chief at the time was French, and said, "What do you mean, the right to liberty?" It came to the fore, and counsel withdrew, apologised, and talked about constraints on the power to detain, and that they were all relieved. There is this real tension that has to be resolved.
All right, so a lot of challenges, incredible time pressure, always out-resourced by the Commonwealth, even when you're well-resourced relative to other people in this space, changing legal landscape, no constitutional protection of, minimal constitutional protection of rights. In Australia, not limited room for international law that refugee law is based on, the need to reconcile the interests of vulnerable clients with the development of a longer-term strategy. I could go on. What would help to ease some of these pressures for all of you? And specifically, is there anything that academics could do to, we've heard in the last session that a number of people in the room see the value in linking academic research with the strategic litigation process. I don't want to repeat that, but I want to get your thoughts perhaps from each of you, and then I'll throw it open to the floor for greater input. What kind of support from academics would most relieve these incredible pressures on you and the work you do? At what stage of the process would it be most helpful to have input from academic experts? What kind of input would be most helpful? Are there particular areas of law or areas of academic work beyond law that would most help relieve the pressure on you? Does it factor more into the building of individual cases or the broader strategic thinking? What can we do to help? Do you want to?
Just be available at 6 p.m. on a Saturday night when we get these calls. I think, like we've talked about, I think setting up relationships for quick and easy access to people that might be able to assist would be useful. I think also, and it's something to talk about perhaps in the session this afternoon, but equally it might be useful for we as practitioners to work with academics as well, perhaps in terms of explaining and working with you about what's involved from our end, just in terms of understanding how a matter might run, what sort of evidence may be useful, what are the rules of evidence when you're working in this space, a bit of an understanding of time pressures, both in relation to urgent matters, the kind that we've talked about today, where you sort of have a 24-hour turnaround, but equally when you're running perhaps more traditional cases where you have a court timetable, there's still I think it's useful to have an understanding of the need to be ready and available to meet court deadlines. So that's just something that's sort of thought about.
So in terms of the stage that we would require the assistance, it really is before we litigate, because that's when we're giving thought to the merits, and if we're sort of thinking about whether it's academic law research or whether it might be an expert opinion, we really need that before we start. In terms of the kind of assistance, I know we've heard from the previous panel about how law academics can assist. I would really be interested in whether there was scope to extend that more broadly across other faculties. Certainly in the bogus document litigation we've run, I was faced with having to find an expert who could give evidence about how the Kabul police station issued passports in the mid-1990s. And the litigation was moving really quickly, and I was literally just texting anyone and everybody, desperately hoping someone would come up with an answer, and they did. And we found a professor who was an expert in that area, and he was very happy to assist. He was very professional, and he knew the area inside out. The challenges then we faced were just trying to capture his time and then trying to find a date where he could actually give evidence, and then we had to organise video evidence because he wasn't going to be in the country. So there are all those types of things involved, and he never ever mentioned being required to be paid, which was fabulous. So that is a challenge too, in that same case we had to engage in a forensic document examiner, so obviously not an academic, but we did have to pay them, and even at legal aid rates that was thousands and thousands of dollars, so that is prohibitive on us doing that type of litigation because obviously the client isn't in a position to pay.
Thank you. To be honest, I haven't had to work with any like live academics in the migration field. What I mean by that is that the area of the Kate, do you want to?
No.
Okay, so the area in which I would rely on academic commentary and that is very peculiar cases, you know, where there's not much law on it at all. So it's actually quite rare. Like I actually did an OSPLE search on, just before I came, how many times in the Commonwealth law cases has there been any kind of reference to the law of refugee status, which is you know, the Hathaway book that is most prominently referred to by judges. Now, there isn't a lot of recent cases at all that do that. There is one recent one which I've actually used in one of my submissions on credibility. So there's a 2018 case, full federal court case, AVQ 15, and it's on credibility assessment. That's an issue that's hot, and that is the kind of area where it's not yet resolved. It's a new issue. It's still being worked out. There isn't clear lines of authority in it, and so they're turning to academic commentary to see, okay, what have they said about it? Because there's often then comparative law involved in that, and especially if they're from already well-known academics like Hathaway, like Goodwin Gill, that are established in the area. So, for example, that's one that's very recent and that's come up, and that will be, I believe, used again. In the past, things like relocation, internal, that has been, when that was an issue, especially complementary protection, when that came up, a very new area of law for all of the judges. They turned to academic commentary on that. What were they saying about the internal relocation principle, especially under the UN conventions? Another earlier references in the 1990s would have been the definition of persecution. So what is actually persecution? Discriminatory conduct? Is it systematic? Again, at that stage, in the very early days, something that was unresolved. So that's when I think academic commentary comes in, because it's really an opinion. It's to the court, it's just an opinion. It's another opinion that they can take into account. And whether they're going to put any weight on that is whether or not there's already been authority that they need to follow. So if they've already got decisions out there, legal decisions that they need to follow, they're not going to look at academic sources at all, because they're not bound by that. If they've got uncertainty, like in the area now of credibility, like in the past of what is persecution, then that's a question that they have unresolved, and they'll look to academic commentary. Because academic commentary also involves comparative law. What are the other countries doing? What's Canada doing about this issue? What's New Zealand doing about this issue? Academics have already had the time, the space, the effort, the energy to write about it. You know, so we don't have to start from scratch and look at the cases. So that's pretty much the only kind of area that I can think of in terms of when I just said my first thing alive. If I could bring on expert witnesses, that would be great, right? About, yeah, what, you know, from Bangladesh or Pakistan, or, you know, that would be awesome. But all I can do is refer to the textbooks, really, most of the time.
So I would sort of urge a slightly different question on this, rather than relieving pressure. What involvement in the partnership, you know, that can be of real, you know, sort of a real substance. That's how I would think of it. I don't really think the teams that I'm aware of that have been involved in are looking for the pressure to be relieved there. It's high pressure. It's a question of whether there are gaps, and so that's how I think it should be approached. And I think it really then depends. The involvement of academics and their work will depend on the case. I think that's the starting point. There are some cases where it won't be important, obviously, even if it's a novel point that's being raised, or partly because, in a way, the arguments. The way I put it is some novel litigation is actually about how you join the dots in terms of statutory construction, rather than having an expert opinion on Article 1D or 1F. It'll depend on the case. The case that I referred to before, which I was going to bring up in this context, I'll just quickly reiterate it, was where Jim Hathaway's work was important, was where the court asked a question. They just needed something. They just needed, a jurist, a respected, academic to draw upon, and there it arose. But no one could have actually thought of that, oddly enough, and yet it just provided that in a way, something for the court to draw upon that we hadn't thought that they might need, and that we thought was sort of trite. I would come back to a point that I just think was raised before, that one of the difficulties here is in courts in Australia. I mean, courts in Australia rarely even refer to the UNHCR handbook, which has been designed to aid states in interpretation, and on that basis, really, I think part of the ambition here has to be to also try and encourage courts to become more interested in academic work. I think that that's one of the things, and I think that it needs to be thought about very carefully, very strategically, how that might be done. Because again, it's a bit like sort of, the notoriously, the constitutional issue, and the fact that there are notoriously few human rights in the Constitution. There's very little in the way of receptiveness, I think, to academic works at the judicial level. And I think so some work should be done on that. How that's to be done, we can talk about later. And I also think a couple of on that point. I mean, the simple point I would say is that courts are far more interested in precedent than the professors. I can put it that way. But that doesn't mean that it should stay that way. There are many areas where international jurisprudence, where academic work and opinion could play a very useful role, and sometimes does. I'd also say that for academics to become involved, almost always, given that this work is very reactive and very responsive, and often does start on a Saturday night or a Sunday morning, it will require academics that have a finite deadlines and really sharp ones. Now, some academics are going to be more used to that than others, but that's a reality, because if things can't be produced quickly and distilled quickly and provided to the team quickly, to counsel quickly, in a manner and a form that is usable, it's probably going to be difficult to bring it in, because the way these teams work, I think the practicalities, and maybe that's a conversation for later with academics who are interested in probably becoming a little bit more aware, some academics, about how this works, how litigation works, how teams work, and how information is disseminated within them, because it's a real creature of itself. There's a sort of a way it happens, which is probably there needs to be a responsiveness from all players involved, including academics.
And also the communications back and forth, but they may not realise it all.
Yes, yeah, indeed. Yeah. So I'll stop at that. But with one key point, and that is, I think there's of course an incredibly important and rich role that academia does play and should play more than it does. Yeah.
Just one other small point is that you may be aware about country information. So country information is very prominent in looking at any of the countries that the asylum seeker comes from. DFAT reports come under country information that's heavily relied on by the Minister. To refute those DFAT reports is very difficult. They're a source that, from the government really, and there's no objective reason why not to rely on them. If you're then relying on something like an NGO, Amnesty International, in my experience it comes up as a lesser reliable source. if you're relying on something like the UK Interior Ministry or something report, which is probably equivalent to DFAT from the UK, that might be better, that might be stronger. So perhaps academics can be a source of country information that is more up to date, but also as credible as a DFAT report. Because that country information is very, very significant when it comes to refugee cases.
A separate point, just quickly, just one practical idea, and that is that academics often, probably more than practitioners usually are invited to sort of international forums, sometimes to present to decision makers, and it's a very powerful role to play. And I actually think that one area would be to think more strategically at times. I'm not saying it doesn't happen at all, but to develop it a little bit more where if academics are presenting to international judges, decision makers, that there be some pretty close collaboration with practitioners about emerging issues, because that's a way to start to get into the minds of decision makers about issues that they might very soon be hearing in their courts. And so one way of influence, or at least developing a conversation, if not starting to influence their thinking around how matters might be approached.
I'm not saying it doesn't happen, but it could be developed, I think. It could be sharpened.
Thank you. I want to throw it open to the floor imminently, but before I do that, welcome Kate Eastman, fresh from an overtime hearing. Thank you so much for being here. And I wanted to loop you into this last question, which I think we kicked off just as you came in, which was how can academics help to relieve the pressures on people that are living strategically in this space? And I want to loop you in because the question of academic involvement in amicus briefs came up a lot in the first session, and I know that's something that you have a lot of experience in and have worked with academics in, so I was keen to kind of get your thoughts.
So I think there's sort of two issues. First of all, what academics can do is often be ahead of the game in terms of the types of cases that can be run and the issues that you might want to raise. So as David said, it's joining the dots. So often what the Academy has is the benefit of time in looking at a series of cases, looking at how the issues emerge, looking at the approach taken by judges. The University of New South Wales is very good in doing an analysis of which judges on the High Court dissent, who are the sort of leading intellects in the area. And so having that analysis of the way in which judges are making decisions and looking at patterns and trends and then matching that with what might be happening overseas can give us as practitioners some heads up on arguments that we might be able to use and the way in which we might work with particular judges. So we're not very good in this country in the same way the Americans are of doing the sort of analytics on judges. So we'll intuitively know if we're regularly appearing for blah 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 and what they're going to be like. Say no more, Federal Circuit Court. But then again, we might also say in a constitutional case, then if we're doing that at the level of the High Court or at full court of the Federal Court, we may need to know what is the likely sort of thinking of those judges. And I think often in this area we're quick to default to the judges who are sympathetic to the sorts of arguments we want to advance. So we all know, like, it's easy to get Justice Kirby over the line. But what is it for the other judges that might make the difference in the way in which the argument's fashioned? And in constitutional litigation, it's not uncommon for an academic to write an article that might be on a case that's making its way up to the High Court. And the judges read those articles, so it starts that thought process. And I think sometimes as practitioners we can connect a little bit more with the way in which the Academy is looking at emerging issues, and we can pick up on those things. So that's a sort of slightly different perspective to how can academics assist us. And the other thing which I'm interested in is, particularly for constitutional litigation, the judges have got to have facts, so they need constitutional facts. And I've currently got a matter in the High Court where I've used some research done by two academics at Monash University, and this is the safe access zones case, so not an asylum seeker case, but one of the issues is what was the degree of harm for women seeking to access the services? And there wasn't really any evidence other than sort of anecdotal evidence. But 2 academics at Monash had done a very significant research piece on that. And so I attached their research paper to an affidavit in an amicus brief to say to the court, here is your evidence of the constitutional fact when you're looking at striking a balance on freedom of expression ideas. And I wonder if we've got evidentiary gaps, that we can use the work done by academics in an appropriate case to sort of fill in the gaps that we don't have. So it's a bit like a hybrid of an expert evident, so an academic as an expert, but actually filling in jurisdictional facts. So I'm really interested in how we can work with the academy on those types of matters.
I might throw it open to the floor now, and I might sort of guide that a little bit, because we've had quite a lot of discussion today on what it looks like when you get effective, active collaboration between academics that are kind of litigation-minded, I suppose, the kind of academics that tend to seek this out, and practitioners working in this space. But kind of a couple of the more recent comments that have come out of this panel have spoken of the value of, and it came up in the last session as well when George Williams mentioned strategic academia. There's a value I'm hearing in academic work kind of being accessible to people in the profession, and in academics being aware of issues that are likely to become hot practical issues. And I want to kind of tap the room on, for the practitioners in the room, how easy is it to come across, like, to what extent does your role involve looking at academic research, and how easy do you find it to find stuff that is helpful? How often do you find it helpful when you come across it, and how easy is it to navigate the research that's out there? And what could make it easier for you to tap into this kind of work in a way that's beneficial to litigation?
I've found many practitioners have signed up to the Kaldor Centre's weekly newsletter. Right. Because that's a really good start in terms of tapping into it.
I was just going to say, often you don't know what you're going to need until you're faced with it. So it's very hard to sort of predict, look, we've got an expert in this, and can you suss that out for us? It would be great if there was just a contact number or email where we might be able to say, look, I've got a case, we think we need either some academic research on this or an expert opinion on this. Are you able to put us in touch with someone? I think that would be useful.
I'd actually just like to touch on something that Kate mentioned, because it has crossed my mind before, the analysis of judges. If someone actually just did a whole statistic going through every federal court judge on every migration case, how many they've allowed in all of the time that they've sat on the bench, and on what basis they've allowed it, and then publish that for every federal court judge, they would all be held accountable. And if they knew that we had on them the stats, I am sure they're going to think twice when they write their judgment next, because I can go back now, do an OSLE search on whoever I'm going to go before in the next week or so, and I have found, for example, that they've only allowed 2 in their whole career on refugee cases or migration cases, right? Now, if that was published in Law Society Journal, something like that, amongst all their other colleagues on the bench, if they knew that they were the only 2 that ever allowed in the whole of their career 2 migration cases, and maybe it was only for the minister, and I'm not joking, I've come across judges like that, they've allowed only 2, and it was for the minister. If they got that, saw that in an article in black and white against all their other peers, that would be a really good pressure valve, like a transparency on them, a highlight on them. So any one out there, Kaldor Centre, whoever it might be, if you want to put that article out and update it every month, and send it out to all of the practitioners, to every practitioner, it will put a whole new complexion on the federal court judges and the federal circuit court judges as well, and how they write their judgments, because they're being kept track. You know? Am I going to be the same pattern again and again for the next 20 years that I'm sitting on the bench? Because it's not a joke. I can look up Osley now, how many allowed, or what cases they were for the minister.
Hi, Angus Francis. Let's go back to that earlier question. As a practitioner, I think for me, my use of academic research will differ depending on what stage of proceeding on that. So with a protection visa application, that's where I'll probably use someone who's a country expert. And there's been a lot of initiatives over the years to try and develop a systematic way that people can actually make contact with those country information experts. So Barbara Harrell-Bond, the late Barbara Harrell-Bond, was instrumental in setting up one of those websites where you can go there and you find an expert, or someone who can help you find an expert on China, for example. So just the other day I had someone contact me from the US, who's doing litigation in the US, contact me because I'm on the China panel, and they said, you know, can you recommend someone? And I looked at their claim and then tried to link them up with an expert. So there are initiatives, and that's always been identified as a very important thing to do. That's really underplayed in Australia, the use of experts for country information. It's much more a big thing in the UK. It's basically de rigueur there, you have to do it. Whereas here it's still emerging. But in a recent series of cases with Church of Almighty God, they were quite active as a group in getting experts from Italy and the US and putting together a comment on the DFAT report, and that we used that comment on that DFAT report, which probably won't go down well with DFAT, but it goes down well with the decision maker at the tribunal level. I wouldn't say necessarily the department level, because the department level is going to really just toe the line. So it's useful at that tribunal stage where you've got people who are more engaged and at an intellectual level. So that's the sort of like nuts and bolts of protection with application, where I, as a practitioner, will be engaging in finding an academic expert who can actually talk to my case or has research on that country or that particular group. And then, of course, as a practitioner, I'll use in those scenarios, I'll use the leading texts and look for particular passages on whatever the particular area is in terms of discrimination or whatever it might be. But that's where I'd probably limit that. I wouldn't necessarily get an academic research rendered to provide expert comment on how whether that case falls within social group or whatever it might be. I just haven't really gone down that route, and I don't think it would be really that beneficial at the department level. I think we'd probably just ignore it anyway. The next step, of course, is then judicial review, and I think that's where it gets so focused on jurisdictional error, and it's so at the moment, like particularly with the IAA cases, Immigration Assessment Authority cases. I mean, we've got literally hundreds of federal circuit court decisions coming out, we've got federal court decisions coming out. Even as practitioners to stay on top of that is very difficult. So for an academic to be staying on top of that is, it'd be great if they could publish something, but I think it's going to be difficult. What I would really benefit from is seeing stats. I would really like to see, what the judge in the federal circuit court in Brisbane is doing compared to other judges in other jurisdictions, because I can tell you it looks like that judge is just saying no all the time. So that would be really useful. And then in terms of using, I'd like to hear from the panel actually, because in terms of using expert opinion for like a point of statutory construction, I think you're going to have difficulty there. I mean, it's one thing to use an expert for what we're talking about before, about sort of factual matter about a bogus document or something. But when we're talking about using a refugee law expert to comment on refugee law or the interpretation of a statute, because it's international law and the role of the court is to interpret the statute and thereby interpret the statute in light of international law, you're going to fall foul of the role of the judge. So, we had this issue, I was involved in the VW class action, and we had this issue where we had a statute, the barristers came up with this idea that, I'm talking out of school, but the barristers, came up with this, we're having an expert to comment on the regulation, and that did not go down well, because in fact it's the judge's role to interpret that. And so I think that you can definitely, refer to leading academic texts. You can definitely, look at Jane's work at complementary protection, look at Guy Goodwin-Gill and Jane's work and Hathaway's work, and bring them in support of your submissions. And you can even use in my understanding, you can use an expert to inform your submissions, but you get in trouble if you're trying to present your expert as the definitive, voice on that particular construction. I'd be interested to hear what you guys think about that, because that's something I've never actually encountered. So, but that's just some of the thoughts I have.
Does anyone on the panel want to comment on that? How do you most strategically make use of expertise in a way that is more likely than less likely to be persuasive in court?
In my experience, I think the panel's already said Australian law is very restrictive, because in our domestic law, we've already we've used our own wording. In making a domestic law, we don't use the wording of the international convention, so it's really difficult to use comparative law in that sense to construe something. Whereas in my experience in Nauru, the Nauruan Migration Act, although it cuts and pastes from Australia, it's different in relation to complementary protection. They actually just take it from the convention. So when I was arguing in the Supreme Court of Nauru, I was able to say, this is the wording of the convention. This is how the word international law interprets the convention. We were doing that for the rights of the child. We were doing that for CAT. And the Silk senior counsel turned to me after the case and said, on my LinkedIn page, I'm going to put in international lawyer now. Because we were arguing international law. That's not possible in Australia. We wouldn't have been able to make those arguments in Australia.
I mean, I basically agree with your point. I mean, I don't think the key role for academics would be to assist with statutory construction arguments. I think that, and partly I just say that because happily the teams that we use are well equipped, and that's what they do every day. I mean, that's in Australia, good lawyers should know how to do that, and so it's really not in that area so much, as in, for example, there are some areas of jurisprudence that are underdeveloped in Australia on certain areas of the convention, interpretation of them, and so courts will occasionally, if they really have to, if the High Court really has to rely on a House of Lords decision, they will, and that is if it's underdeveloped in Australia. They prefer not to, of course, and they sort of look at each other sometimes in exchanges and go, oh, we have to rely on some English authority, and then but that's where there could be some role for academics. That's one of the areas, is to assist with that, because sometimes the authority overseas can be unhelpful too, depending on where they go. And where they go can often be very, very selective, where the High Court goes for authorities internationally. And so that's an area sometimes where in legal terms we will go, right, we've got to overnight, we've got to get an army together of researchers to now go down this route, which we didn't realise the court was going to be so interested in, on the interpretation of, for example, what does a legal entry mean in the convention? What's the jurisprudence on that, which may be underdeveloped here. That was one example I can think of. And that's where an academic who's done work in that area could be very useful to just assist in the team. They may readily know, obviously, things that are not known in the team about jurisprudence and lines that could get the court interested. And that, in the case I'm thinking of, there was some quite unhelpful jurisprudence that it was quite recent in the UK. And it would have, we were fine. We ended up, working overnight on it. But it would have probably been one of those areas where it would be good to bring in an academic on it. I'm not sure we did, but it would have been good to do that. Just for another perspective, are there some other authorities, competing authorities in other jurisdictions, for example? But I also think the other thing that from today, and it certainly came through the first session too, is that another role. I think there are different points in litigation where academics could play different roles. So I think that partly depending on the case, the formulation of arguments, there could be some assistance in the team with formulation of arguments, particularly where, again, there are doctrinal issues that go to international law that could be incorporated. So things like that just involved as another voice in the room, another sort of contributor in the development of argument.
Jane?
Thank you. Something that might be of interest, having heard what you've suggested about drawing on a wider cohort of experts on country information, but also in different disciplines and from all over the world potentially, is that right now in Geneva, like literally right now, there is a meeting being run by UNHCR, which is the very first meeting to scope out a global academic network, which is part of the Global Compact on Refugees, due to be adopted next month. And it just occurs to me, I think, having read the briefing note, I think there was something about strategic litigation, but perhaps we should feed a message back there to consider, just reflect some of these thoughts through to the Kaldor Centre person who's over there, to mention that, because I think having an academic network is all well and good for its own internal purposes, but if that can actually help support refugee protection more broadly, then that's a very positive outcome. Is that a general sense that would be helpful? Okay.
Yeah, mainly because at its heart, really, a lot of strategic litigation it's a tool to introduce normative principles into the legal process in domestic jurisdictions, and so it makes complete sense, and in every sense, that academics should have a leading role in the development of normative principles and opinions on them. Should have that sort of role both here and internationally. That be linked up. Be linked up.
Are there any other thoughts from the floor on anything coming out of this panel? Natasha.
I'm just going to, sorry. I just wonder whether, sorry, Natasha Yacoub, UNSW, I just wonder whether there's scope for academics to work together with practitioners on statutory change more broadly. So that would involve a different type of collaboration, I think, not just the case-by-case work, but working with a different set of actors. So that's the question. So like parliamentarians and advocacy groups and so on. Either actively through briefings or behind the scenes, and then to cooperate on that.
I actually might have a question to add to that. Just working on statutory change more broadly. So whether academics and practitioners can work together.
What we're about to get into in the next session is a kind of a dive into a bit of the detail, but just to preface, because it actually relates to your question, I think one of the motivations for both Kaldor and other organisations involved is that this be used as a kind of pilot of how this collaboration between academia, practitioners and NGOs can work, with the intention that is then spun out across basically every public interest issue you've got in the country, and that then actually leaves you to talk about those sorts of questions in that context as well. So, you look a bit confused.
No, I'm just thinking, yeah, that's fine. I was thinking more very specifically about particular issues. We can discuss it after the break.
What's one?
Like the IAA, for example.
Yes,
so it's a classic example, I would say, where parliamentarians might not understand what the problem is with the IAA, except practitioners and academics will know it back to front.
Yes.
So, you know, when you have a discussion with a parliamentarian about the issues with the IAA, you would need academics and practitioners and or, you know, preferably both together to have done some work to explain exactly what the very serious issues, procedural issues and broad issues with the IAA are in order to ensure, you know, change.
Yeah, that they understand how it works.
Yeah.
So we haven't done so much of that in the refugee space, but we certainly do that in modern slavery and domestic violence. And being a large law firm, we tend to do the research rather than the advocacy. So we would go to a specialist community legal centre that would work with that. But I can see why academics would be just as good, better than us at doing that work as well.
I think one of the problems in the area is that it's become so politicized, and that those that work in the area day to day are often wrongly perceived as sort of well, that's one possibility as being described as un-Australian, but I didn't have that exactly in my mind. But I think that also, I'll say something as I normally say in these forums, but the truth of it is also, in a different context, that strategic litigators are in fact, in a broad sense, political actors in one sense too. Not operating politically in a politically motivated way, but they're part of the system. We are when we do it. And I think that's just a natural part of the system. But I think that the role of academics is different, and that having a different voice in the room, which may not be, whether wrongly or rightly perceived as being partisan, I think you almost always it's the wrong judgment, but nonetheless one that's difficult sometimes to